seated. Before we bring the jury in, I just want to double check. Ms. Anderson, is it still your desire to testify, ma'am?
I would like to testify and have an opportunity to defend
And you're entitled to that.
But you don't give me an avenue to get counsel that's interested in an unbiased representation.
Okay.
And I do have I just want you to know, I have a constitutional right for counsel of choice that I can hire with my own funds. And then I just want you to know that you cannot deny somebody that.
Okay, ma'am, all I asked you was whether or not you wanted to testify.
I want new attorneys and I want to be represented up there.
That's not answering my question.
It's illegal to have me testify without effective assistance of counsel.
Ma'am, my question is this. Do you wish to testify or not?
Yes, I'm going to tell you in front of the jury that I do not have effective assistance of counsel. So my rights are being violated. It has to be on the court record so I can have this appeal. You can't deny someone their constitutional right to counsel of choice with their own funds. You can't deny somebody that and retain your job on the bench. You understand that, right?
I'm asking you one simple question. Do you wish to testify in your own defense?
I wish to stand up there and tell the jury that I've been denied that constitutional right.
Well, if that's the extent of the testimony you wish to give to the jury, I'm not going to let you do that because that's not really relevant to their question on guilt or innocence. Those are other issues that we've already vetted many times over.
But you didn't allow me the ability to defend myself or resolve the problem, and you violated my civil rights against choice of counsel. So you can't keep your job when you do things like that. There's disciplinary steps. You can't deny somebody's constitutional rights.
You wish to testify in your own defense with regard to the crime itself.
With effective assistance of counsel. I am unrepresented because they cannot take their personal bias out of the picture. I went against my own best interest to stop talking to them because I had to protect myself from their malpractice, and you're blaming me. They're abusive at the meetings, so I can't go to those. They lie to me, so we're not getting things effective counsel. I bring it up in court, and you deny my ability to have avenues to correct the problem.
It's my job to rule on issues. I've ruled on these issues many times over. I know you disagree with the rulings, but those are over with now.
But I disagree with my constitutional rights being violated.
Your Honor, can we have just a second?
If you wish, counsel, go right ahead.
Thank you, Your Honor.
You're welcome.
Are you sure? I just want to know. I just want this clear on the record. So you're denying me to have the ability to bring in a professional mediator or add a private attorney to the existing to resolve the problem?
Ma'am, we're at the end of this trial almost.
Yeah, you never let me speak in court. You talk over my head like we don't know what Anderson wants, and I'm sitting right here.
Ma'am, I'm doing my job now. My job is to find out whether or not you want to testify in your own defense with regard to these charges, not whether or not you want to get up here and give a speech to the jury about how everyone's violated your rights. They're two different issues. So tell me, do you wish to testify in your own defense with regard to the charges that are against you? That's my question. Yes or no, we'll do it.
I just want on the record that you're denying my ability to get a mediator and to bring a private or bring a private attorney on here to resolve the problem. I just want that on record.
Okay, it's on the
So
record.
is it on record?
It's on the record.
Okay.
She's got it on the record so many times, I don't think anybody will miss it.
Okay.
Do you wish to testify in your own defense with regard to these charges?
Not without effective assistance of counsel.
Well, I've made the determination that you've been afforded effective assistance of counsel many times in this case. I will reassert that at this point in time. So I guess then the answer is you don't wish to testify.
I want to state very clearly on the record that my reason for not testifying is because I do not have effective assistance of counsel.
Okay, then that's your record, ma'am.
Yeah, thank you.
And Mr. Sorensen, Ms. O'Connor, anything more to add to that? I don't know that there is anything more to add.
I just wanted it on the record, Your Honor. I don't mean any disrespect.
I understand, ma'am. I'm just trying to figure out where we're headed from here.
Okay.
So she will not be testifying, is my understanding.
That's my understanding. I don't want the record to somehow indicate that we have in any way talked her into not testifying. I think that I just want that to be clear, because the question was leading from Your Honor. She will not be testifying. So I just want to...
Somebody has to make a final conclusion here, and I guess that has to be me, because I can't seem to get a straight answer out of Ms. Anderson, except that she won't testify without effective assistance of counsel. She claims she does not have effective assistance of counsel. Putting those two things together leads me to believe that she doesn't wish to testify, and she's nodding her head in agreement to that as I speak. So I think that's the best I can do, Mr. Sorensen. And again, I don't want anything in the record to seem to suggest that somehow you or Ms. O'Connor is involved in some sort of goading her one way or the other. I'm not suggesting this. I'm just trying to get a straight answer on the record for whatever later purpose it might be needed. That's all.
Well, it seems like we have it at this point.
I think we do. I think we do.
Yeah, if I had effective assistance, I would be up there.
Fair enough. So we have that.
Yeah, and
So
they have not told me to testify or not to testify.
That's
They
right.
have not told me anything either way. I confirm that.
I understand that, ma'am. So with that, Ms. O'Connor, Mr. Sorensen, I don't think you have any other witnesses to call, correct?
That is correct.
Correct.
And so I think that obviates the need for any rebuttal witnesses, right, Mr. O'Toole? So we need not fret about...
And I guess theoretically,
Theoretically and actually, I believe. So I will bring the jury in, and counsel, you can rest on the record. Pursuant to the agreement that I think we came up with yesterday, we'll defer closing arguments till tomorrow and excuse the jury for the day. Is everybody on board with that plan?
yes, Your Honor. And then did you want to go into jury instructions now, or could we have a couple of instructions?
Why don't we go into jury instructions at about 1:30 so that you have a chance to look at the defenses, I get a chance to go and see what changes there are, because some of them, for my purposes, look like the same one, but...
There's, just for the court's edification on 101, there's
102 was it?
102, excuse me. There's the language that they didn't use in McEnroe, the state didn't propose about, you have nothing whatever to do with punishment.
Yeah.
That sentence was omitted from the states, and it's included in the defense.
Oh, okay.
And then the one about the defendant's right to testify or not, the WIPIC says required, and the state's proposed says compelled. So there's just some very minor differences
tweaks.
between the two. If just
102 is so long, I didn't see
Right.
any immediate change to it, to be
Right.
honest.
And I had used the McEnroe as a template, which obviously that sentence made, in that condition made some sense.
So I think we just solved the problem with 102. We're using the defenses, because that's the standard one, as opposed to the McEnroe tweak.
Exactly.
Right? Okay,
Right.
terrific. So we resolved one of them at least. Okay. So let's get the jury out here. You guys rest on the record, and I'll give them further instructions about tomorrow. Thank you. And the state, having rested its case in chief, Mr. Sorensen, Ms. O'Connor, does the defense wish to call any witnesses at this point in time?
No, Your Honor, the defense rests.
All right. So, ladies and gentlemen, what that means to you all is that concludes the presentation of evidence in this particular case. So, the next order of business will be to provide to you closing argument. Before we do that, counsel and I have to get together and craft the jury instructions that will guide your deliberations in this case. So what I'm going to do is I'm going to ask you in a moment to leave your notepads and pens there on the chairs. I'm going to excuse it to the jury room. Kenny will release you for the rest of the day today and have you report back at 8:30 tomorrow morning. We'll reconvene at 9 o'clock. At that point in time, you will receive copies of the jury instructions that will guide your deliberations. I will read those through with you so that you'll be familiar with the law that you will be applying to this case. And then you'll hear closing arguments of counsel. And then after that is all done, I'll be selecting two numbers at random to designate the alternates on this jury, because as I told you, the alternates are not pre-designated at this point. So we still don't know who that's going to be, and we won't until the end of closing argument tomorrow. Then the remaining 12 jurors will convene to deliberate on a verdict. So I think that sort of brings you up to speed as to where we are. I think it's consistent with what I told you last week, where we were anticipating that you would be in deliberation sometime this week. So it'll be tomorrow afternoon in all likelihood. So with that, again, thank you so much for your service. I appreciate your patience as we go through this process. Again, resist the temptation to discuss the case with anyone tonight or do any of your own independent research. You'll have an opportunity to chat amongst yourselves about this case shortly enough, okay? Thank you very much, folks, and I'm going to excuse you to the jury room. Please leave your notepads and pens on the chairs there.
You're such a good. Look out.
Michelle, have anything you want to say to us?
Proud of you, girl.
Good job.
I know. It's violated. All right. He was a fool.